On behalf of the High Court Bar Association, I would like to welcome your Lordship.
Thank you very much.
Maiden visit to Kohima as a judge.
Yes, I had come as a counsel, but not
As a judge.
in fact, I was very informally narrating to somebody. Said, "Have you gone to Kohima?" I said, "I'd gone to stand, but not to sit." Okay, my stint is for 2 weeks. Let us hope that we do some constructive work with your able assistance.
We look forward.
Yes.
Lordship, hearing item 11,
Yes.
that is the first hearing list. May I pray that this matter may be adjourned to 2 weeks, Lordship?
11 is the 18 matter.
Yes.
Where are you seeking time?
Lordship, I'm handicapped with my juniors. They have the personal difficulties.
We'll adjust your difficulty for 2 days, not for 2 weeks. 18
Let the
matter,
days
18
be turned to W.
18 matter, no adjournment for 2 weeks. We don't adjourn. 18 matter. We'll accommodate you, give you enough time to prepare. Do it on the day after tomorrow.
Let it be on Thursday then.
Thursday is a holiday, I think.
Wednesday is a division bench day, Lord.
Okay, then Monday next.
Lordship. Lordship, I have a fixed matter in the principal seat on Monday.
Tuesday? Is it okay?
Tuesday, and only on Tuesday I may return.
Okay, on Wednesday next.
That is a division bench again.
Then tomorrow. Tomorrow. Prepare, you don't need a whole day to prepare. You are such a seasoned senior counsel, you don't need to retire. Tomorrow.
My assistant junior has some problem, Lordship, that's why. Otherwise,
But we'll have this matter.
I'll be glad to do the case, Lord.
But this is the division bench. Okay, then Thursday next.
Lord.
Thursday. On a request made on behalf of the petition, a request for adjournment has been made by Sri Siti Jamir, Learned Senior Counsel for the petitioner. First of, however, considering that this writ petition is of the year 2018, a short accommodation is granted, directing listing of this matter on 30.
May I please, my lord?
Yes.
Lordship, I beg to mention item number 7.
Yes.
Lordship, I'm mentioning on behalf of my colleague KV. I am told that he is yet to file his contract for the state respondent, my lord. If 3 weeks time can kindly be granted, my lord.
You're for the petitioner.
No, for the state respondent.
Okay, you have not filed the counter.
Yeah, yes.
Okay. What is the matter about?
Lordship, I am making a mention on behalf of my colleague.
What is the matter about? What is the subject matter?
Lordship, I am not handling the brief, my lord.
It is not accepted. You should know the subject matter at least. Okay, you are for the government.
Yes, ma'am.
A prayer for adjournment has been made on behalf of the state to enable filing of counter affidavit. List after 3 weeks.
My lord. I deeply observe.
You have taken the consent?
Yes.
Your Lordship.
Yes, please.
Lordship, I beg to mention item number 3.
Yes.
Item number 2. Your Lordship, in this case, an affidavit of opposition has been filed. There are some personal allegations against me. I need to find the rejoinder to that affidavit. So if I can be given 2 weeks time, otherwise the matter is ready for hearing. You can come up for hearing in the usual course. Just for me to file a rejoinder matter.
What is the subject matter?
This is about the payment of land compensation. So the allegation is that compensation which was given to the village has been misused. That is the allegation. Misappropriate.
Let the matter reach, we'll see.
Very well.
Okay. Anything?
My lord, I beg to mention item 19.
19. Yes.
For 2 weeks, my lord.
Here for whom?
I'm praying for petitioner on behalf of peace friend.
Why do you want adjournment?
After 2 weeks, my lord.
Why?
The written counsel is facing some personal difficulty.
We adjourn for a week, 1 week, not 2 weeks, 22 matter. A prayer for adjournment has been made on behalf of the petitioner. Full stop. List after a week.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 3, Lordship.
3 years.
Here, Lordship, we are yet to receive instruction, Lordship. So
You for whom?
I'm for the state respondent. Lordship. So if Lordship may please grant, release the matter after 3 weeks. Lordship. That will have been-
Who's for the respondent number 4? Somebody has entered appearance for respondent number 4.
Yes, sir.
Yeah, for the respondent number 4. Have you filed your affidavit? Will you file your affidavit? So the prayers will come for you. You are for the state.
I'm for the state respondent. One
State
thing.
has filed affidavit, I think.
No.
State has filed affidavit.
No, Lordship, no, Lordship.
Okay, let the matter reach. We'll just have a look. We'll accommodate, don't worry. Let it reach.
Lordship, I beg to mention hearing item number 16 and 17, Lordship. On behalf of additional AG in Team Song, Lordship. Lordship, if this matter can come up next week, Lordship.
Some difficulty today.
Your
Lordship,
Lordship, the other side, the parties on the other side have been taking adjournments repeatedly. Others have always been very smooth.
On Monday next.
On Monday.
Okay,
And
Monday.
if I may also seek the Lordship indulgence, in item number 17,
Yes.
the Lordship, there is a petitioner who is student number 66. He is in some adversity. And for persons who wish to accept damage compensation, they are being paid damage compensation. He wishes to withdraw from this petition.
66.
66.
Okay.
Item 17. Madam.
Your good name, please.
A. Zimomi.
3A Jimoni.
Zimomi.
Jimoni Learned Council for the petitioners submits on instructions that petition number,
66.
but there are 31 petitioners. Oh, in
Item
17.
17, item
On 17.
Yes.
Submits that the petitioner number 66 does not want to pursue in this litigation and wants to withdraw from the case.
Yes,
Full stop. Also heard results in the state council. Para, in view of the aforesaid submission, comma, the name of the petitioner number 66, Nam to delete, is struck off from
Yes,
the
ma'am.
array of parties.
In WPC number 50.
Yes, we have noted.
Yes,
50 of
Yes,
2022.
ma'am. Much obliged. On Monday, my lord?
Yes. And you write on the main, first you write, a prayer for adjournment has been made on behalf of the state. Full stop. However, this prayer is objected to by Sri A. Jimomi, Learned Counsel for the petitioners. Full stop. Considering the same, a short accommodation is granted, directing listing of these matters on Monday. Okay.
Much obliged.
Lordship, I also beg to mention hearing item number 12 to 14, Lordship. On
Yes.
behalf of my colleague, Viveka Singh, Lordship,
Okay.
for the state respondent.
Okay.
Lordship, if this matter can come up after 2 weeks, Lordship.
Why are you mentioning gold matters?
Lordship, I'm mentioning on behalf of my colleague.
No, no, understood. But why are you mentioning for 2 weeks? We'll accommodate you 2, 3 days, 3 days. These are old matters. Personal difficulty, how many days? Cannot be for 2 weeks. We'll have it on Monday next. Monday next. Whole matters, please don't request for an adjourn unless there is something very urgent. 12 to 14. A prayer for adjournment has been made on behalf of the state. Full stop. Accordingly, matters are adjourned to be listed on Monday next.
Or else, Lordship, on Tuesday, Lordship.
Tuesday next. Okay, no problem. Tuesday next.
Please, Your Lordship. Lordship, I mentioned on behalf of additional AG in Team Song.
Which matter?
Item number 22.
22 years.
Yes, we are yet to receive instructions, so kindly grant 3 weeks time to file affidavit.
22 is an admission matter. On a prayer made on behalf of the state, matter is adjourned by 3 weeks to enable seeking of instructions / filing of affidavit in opposition. 3 weeks.
Lordship, I also have a similar prayer for item 10 on behalf of additional AG.
You have not filed affidavit in opposition? Okay, so 10. 3 weeks.
Oblige, your Lordship.
So Lordship, Your Lordship, I beg to mention item number 9, Your Lordship. Here, I'm representing the state, Your Lordship, and I'm here to receive instructions. So kindly grant 2 weeks' time to obtain instruction and file affidavit, Your Lordship. Item 9, Your Lordship.
9.
Yes, Your Lordship.
What is the subject matter, madam?
Here, the petitioners are seeking promotion, Your Lordship. It's a promotion matter.
Promotion.
Yes,
You are for
Your
the petitioner?
Yes, Lordship.
Yes?
No,
Grant
petitioner.
3 weeks then? Okay, XM order, 3 weeks. Sir. You file the affidavit within 3 weeks.
Yes, Your Lordship. Your Lordship, I also beg to mention item 4 and on behalf of my colleague, Your Lordship. Here, the pleadings are complete. So this may be listed for admission hearing after 2 weeks, Your Lordship.
It is for admission hearing. In your affidavit in opposition, you have said that this matter will be sent to the cabinet. What is there to be
Your
decided?
Lordship, I'm mentioning on behalf of my colleague, Your Lordship. She
No,
has,
we'll let the matter reach. I don't think there is anything left for adjudication.
if it may be taken up next week, Your Lordship.
Let it
because-
reach, let it reach.
Oh, yeah, oh, Your Lordship. Your Lordship, also item 6, Your Lordship.
6.
She's,
Will there any matter be left for adjudication today? We have not come all the way to have
yes, Your
adjournments.
Lordship. But in this.
Today
matter-
I am granting, but tomorrow onwards, unless you assign some good reasons, no adjournments.
Yes, Your Lordship.
Let the matter reach, then we can grant you time, but not at 10:30. Doesn't look good
Yes, Your Lordship.
if you rise at 10, 11 o'clock.
Your
Yes, item number?
6, Your Lordship, here, my colleague, she's yet to receive instructions, Your Lordship. Or 3 weeks time may be granted to file counter, Your Lordship, on behalf of AIM.
What is the subject matter?
Your Lordship, I'm not handling this matter, Your Lordship, so I'm not aware.
You
Your
should
Lordship.
know the subject matter. Before you mention, know the subject matter at least. Acha, 6, same order, 3 weeks. Huh?
Much
We're granting you 3 weeks.
obliged, Your Lordship.
File the affidavit.
May I please, Lord?
Yes, sir.
I repeat to mention item number 18.
1-8.
Yes, I am filing a reply to Accountant General affidavit. So can it be accommodated tomorrow? I am filing it today.
Today.
Yes.
Okay, we'll have it
Either
tomorrow.
Tomorrow?
Okay.
Yes.
It is submitted that the rejoinder affidavit to the affidavit in opposition of the Accountant General would be filed during the course of the day.
My lord.
Full stop. List this matter tomorrow along with the rejoinder affidavit that may be filed.
Much obliged.
Okay.
May I please, Your Lordship. Your Lordship, I beg to mention item number 5.
5 years.
Your Lordship, here pleadings are completed, so kindly the matter may be listed after 2 weeks.
Why? Pleadings are complete. We'll have it today.
Your Lordship, my senior is indisposed today.
Okay. We'll have it when?
After 2 weeks,
No,
Your
no,
Lordship.
not after 2 weeks. We'll have it on Monday.
Then, Your Lordship, kindly it may be next week,
Next week, next Monday,
Thursday,
next Thursday.
Yes,
Next Thursday, we
Your
already
Lordship.
fixed a big matter. Or Tuesday.
Tuesday, okay, Your Lordship.
It is submitted that pleadings are complete. No, it is submitted that the learned pleading council is unwell. And a prayer for adjournment, a prayer for accommodation has been made. Full stop para. List on Tuesday next. Tuesday.
Much obliged.
For motion, item number 20.
Please, my lord.
Yes.
Lordship, I have actually served copies to the Learned Central Government Council, Lordship.
Who's there for the CGC, for the central government? Any CGC? Are you equipped with this matter?
Lordship, Lordship, I will take notice on behalf of respondent number 1.
Where is the so-called notice? You have
Lordship.
annexed the reply. Where is the so-called notice?
Lordship, I could not trace it, Lordship.
No, you have filed a reply. How can you say that you have not?
Lordship,
given-
the petitioner, Lordship, she has lost a copy of the show cause, Lordship. But I have replied, and after that, Lordship, the impugned assessment order has been passed, Lordship.
No, what is your good name, Mr. Counsel?
My
What is your name?
Sindiangar, Lordship.
You're
My
not-
name has not been reflected in the cause list, Lordship.
Cynthia. Okay,
in my
doesn't
credit
matter, doesn't matter. Mr. Counsel, you see, this, you are alleging that you belong to a particular community
Lordship,
which is
Lordship.
exempted
Yes, Lordship.
under section 1026 of the IT Act.
Yes, Lordship.
Now, exemption is only from the purview of paying the income tax.
Yes, Lordship.
You don't need to pay income tax
Yes, Lordship.
for certain incomes which are generated within the state. But that will not amount to not filing of the returns. You have to
Yes,
file the return. Payment of tax is a different facet altogether.
Yes, Lordship.
And disclosing in the return is the other aspect, which you have not filed returns.
Yours, Lordship, those steps my client will take, Lordship. But
No, it's not a question of client taking steps now.
Yes,
The returns have to be filed in time. You have not filed the returns. For demanding the income tax, we may protect you. That's a different aspect.
yes, Lordship.
But you are not precluded from, or there is nothing in the act which
Yes,
will
Lordship. Lordship.
require not to file the return. You have to file the return.
Yes, Lordship.
Disclose everything, then you don't need to file.
Yes, my lord is right.
But you have not filed returns.
Yes, Lordship.
If
I
you have
have-
not done or discharged your obligation,
Yes,
what
I have-
protection can you have?
I have advised her to take necessary steps, Lordship. And she is pursuing them, Lordship, at present.
And where are the sale deeds?
The sale deeds, Lordship, those sale
Where-
deeds
where?
also, Lordship, it is with those people, Lordship.
Which
She did not
people?
keep a copy of it. Lordship, this lady, she is a simple woman, Lordship. And just because she inherited the plot of land from her father, Lordship, and then it was agricultural plot
See,
of
a
land.
simple lady having a bank account at Delhi, SGFC, one account at Nagaland.
Lordship,
We
yes,
understand how simple she is.
Yes, Lordship.
See,
Now,
no, we are not doubting her simplicity.
yes, Lordship.
But that will not mean that she will not retain a single paper. You are maintaining bank accounts in Delhi.
Yes, Lordship, now she is communicating. She's trying to establish contact with those people.
See, you have
who-
not given the copy of the show cause notice, number one.
Yes,
You have not annexed the sale deeds. We
Yes,
do not know
Lordship.
where the land
yes,
property
Lordship. Yes,
situated.
Lordship. Yes,
Prima facie, you have made out a case that you
Yes.
don't need to pay.
yes,
You belong to the
Yes.
ST Hills.
yes, Lordship.
You are exempted from paying under 1026.
My lord.
But you have not filed returns even.
Yes, Lordship.
Mr. CCC, you take instructions.
Now, Lordship,
We'll issue a short notice.
Lordship.
We'll grant a kind of a
Lordship,
conditional protection, not
the-
final
The
Yes.
respondent number 2, they have a separate
counsel.
council, yes. So
Have you
if
served on the
ma-
council?
no, Lordship.
Please serve on the council.
Lordship, if I may be allowed to serve by trustee service, Lordship,
No,
because
no,
the council,
they have a separate council, we have been told.
Lordship,
Respondent number 2.
Oh, yes.
I will be appearing for respondent number 1.
Who is this council?
I'm not aware, Lordship.
No, kindly inform your friend or your colleague.
Okay.
He can serve it today. We
My
can
lord,
have
my
this on when?
I can have it served today, Lordship.
Then tomorrow we can have it.
Yeah, he's one.
You can give him a call. You can give him a call,
Yes,
apprise
Lordship.
of the matter. Ask
Yes,
him to come tomorrow because the Wednesday we have been told there's a DB.
yes, yes, Lordship.
Thursday, Friday are holidays
My
here.
lord.
It can go to Monday. And these matters we want to adjudicate and pass some orders. There is a
Lordship.
demand against you.
Lordship.
Ultimately, you are aggrieved by the demand of the tax.
Yes, Lordship.
That you may be exempted. That's a different matter. But when can we have it the earliest? Tell us.
Lordship. By
Monday, can you wait till Monday?
my lord, my lord.
Okay. This court has been informed that the respondent number 2 Income Tax Department has a standing counsel,
Yes, yes.
namely,
I don't remember his name.
please give it
This
to
one,
our
yeah.
secretary.
Alright.
Azuri Pare, huh? Learned counsel for the petitioner undertakes to serve a copy of the petition to the learned standing counsel income tax. Full stop. Para. Let this matter be listed for motion on Monday.
My lord. My lord, if,
And in the meantime, try to get those documents.
yes, lordship, lordship. In the meantime, if interim protection can be given at least till the next date, lordship.
Till the next date fixed, comma. No coercive action be taken against the petitioner in terms of the impugned notice dated 19/2/2024 by the income tax department.
Yes, as well as assessment order dated 19/2/2024, lordship.
Impugned orders, huh?
Orders, yes.
Okay.
19/2/2024.
Yes,
My lord.
the aforesaid interim protection, however, would be reviewed and reconsidered on the next date fixed.
My lord.
Okay, Monday.
Much obliged, lord.
And try to get hold of the documents.
My lord, my lord, my lord.
Yes.
Deeply obliged.
For motion, item number 21.
May it please your lordship. Lordship, this is the second writ petition.
Yes.
Earlier, an order has already been passed that it should be given scale pay. And scale pay would mean the current scale pay, not a scale pay.
We
being-
will issue notice here.
Very well, ma'am.
You are challenging certain clauses of the
Schemes.
schemes of 2004 and 2015.
Yes, ma'am.
We'll issue notice, madam, at this stage.
Yes, your lordship.
For 3A Jimomi, learned counsel for the petitioner who has put to challenge certain clauses of the schemes of 2004 and 2015 pertaining to regularization of service.
Yes, ma'am.
Full stop. Para, let notice be issued. Returnable by 6 weeks. Madam, for
All the
One
stages.
1 to 3, your lordship.
all the respondents,
Yes, all the respondents.
you are the state counsel
Yes, your
for
lordship.
all the respondents. Para, let extra copies of the petition be served upon her by tomorrow.
Very well. Much obliged.
Yes, your-
If I may, my lord. My lord, if my name can kindly be reflected in the cost list in item.
Doesn't matter, okay. Don't remember. It's in the file of us. Sent here.
For admission, item number 1.
May I please, your lordship?
So you're very happy?
Lordship,
Very good case over.
no, your lordship. Your lordship, here I have instruction to withdraw the matter, your lordship.
Yes, very good.
Lordship.
There were very serious allegations of suppression.
Lordship.
So you have taken the best resort, withdraw. Your name, good name?
I'm sorry, your lordship.
You're not there on record.
Lordship, it's there, your lordship. Number 3, your lordship.
M
M
Solo,
Solo.
okay, okay. 3M Solo Learned Counsel for the petitioner submits that he has instructions not to press this writ petition. Para also has referred to Learned State Counsel, who does not object to the same. Para, writ petition is accordingly dismissed on a trial.
Lordship, much obliged.
Item number 2.
Your lordship, here I am the private respondent. And the allegation is against the Mailamsi Village Council. And this is about the compensation which was paid for the construction of National Highway 139A.
You had paid for some time in the
Yes, ma'am.
morning.
I wish to find a reminder to the affidavit reply. Some more personal allegations have been made against me, and they rely on some certificate.
Who has filed this counter affidavit? Which respondent?
The petitioner. The petitioner. The petitioner has filed
A rejoinder.
an affidavit in reply to my affidavit in opposition.
Where is the scope of filing further pleadings?
In the affidavit in reply,
No, where is the scope of filing further pleadings by you?
with the permission of this court, Your Worship.
Pleadings have to end.
But if there are personal allegations against me, now again, and then some.
Let us see what are the personal allegations, what nature. Please read it out.
It's a very lengthy paragraph, my lord.
Doesn't matter, you just indicate. And was there any such allegations in the writ petition?
Allegation was there,
In the writ petition?
in the petition was there, and then it has been again amplified.
We'll take care of, but this will,
Otherwise, Your Lordship, this is purely a civil dispute. Disputed questions of fact.
those aspects we'll definitely consider. If we find that these are disputed questions of facts,
Yes, Your Lordship.
we may not even enter into the merits. That's a different
sir.
aspect.
So what they are saying in the petition, what they are saying is that they are residents of my city. And that for some of their properties,
If you're ready, we can have a hearing today now. If we feel that you are entitled to file a rejoinder, further reply, we'll give it to you. Otherwise, we can go ahead. Yeah, for the petitioner. Are you ready or not?
Actually, my lord, the state has not filed their affidavit yet.
State has not filed.
Yes.
Yes.
My lord. I'm for state respondent.
Would you like to file any affidavit?
Yes, my lord.
You have not filed. This matter is pending since a year.
We are yet to receive instructions. Yes.
Rejoinder affidavit has been filed by the petitioner so far as the private respondent is concerned. You are yet to receive instructions.
Yes.
Get the instructions fast. At least get the instructions, whether you file or not, that's a different matter. At least then you can assess the court. We grant 2 weeks time. And
Yes,
we'll have your thing also considered, okay. It appears that though affidavits have been exchanged between the petitioner and the private respondent number 10, comma, the state is yet to file affidavit in opposition, full stop. Sri Jimami, the learned counsel for the respondent number 10, has also made a prayer seeking leave of this court to file further pleadings. Full stop, para. Considering the above, comma, matter is adjourned by 2 weeks to enable filing of affidavits. Yes, anything? Filed? We'll record your presence. Please give your name. Whoever is there, please give their names. We'll record the presence.
much obliged.
For admission, item number 3.
Item number 3.
I'm for the respondent number 1, 2, and 3. Here we are yet to receive instruction, Lordship. If Lordship may please to grant another 3 weeks time, Lordship.
And R4, for respondent number 4. You have filed affidavit? No. Why you have entered appearance, you have not filed affidavit? We grant some time? Okay. On a request made on behalf of the state, as well as on behalf of the respondent number 4, 3 weeks time is granted to enable filing of affidavit in opposition.
Lord. Hello.
Item number 4.
Your Lordship, here the petitioner is seeking for service regularization, Lordship, as per the office memorandum issued by the PNR department.
Okay. Madam, in the affidavit in opposition, in paragraph 6, do you have the affidavit in
Your
opposition?
Lordship, here, I'm not handling the matter. I was mentioning on behalf of my colleague earlier, Your Lordship. If it can be taken up next week, Your Lordship.
Tomorrow
I'll
we'll have
inform-
it, tomorrow will your colleague be there or not?
She's indisposed, Your Lordship. So next week, maybe.
Next
or
Monday, we'll dispose this of on Monday. We have seen there is a statement made in paragraph 6
Yes,
that the
Lord.
matter has been sent to the cabinet. So we'll fix some time broadly and let the matter be finally decided by the cabinet. Okay. A prayer for adjournment has been made on behalf of the state on the ground that the concerned state council is unwell. Puts the para. Considering the above, list this matter on Monday next.
Much obliged.
Item number 8.
May I please, Your Lordship? I'm appearing on behalf of my colleague, Lee Kasim, Your Lordship, for the state respondent.
Who is for the petitioner? No one is there. You have not filed affidavit.
Lordship.
No, none appears for the petitioner on call. Para, affidavit in opposition. Are you for the petitioner? No. Yes. You're for the petitioner. Don't write none appears. Yes, what? He's seeking time to file affidavit. Don't say none appears. Huh? On the prayer made on behalf of the state, a matter is adjourned by 3 weeks to enable filing of counter affidavit.
Item number 15.
Yes, what is this?
Remember the petitioner is Assam Rifle personnel. Yes. What happened is that he was dismissed on the ground that he violated Army Act. It is not applicable in the Assam Rifle.
What rules are applicable for Assam Rifle?
Assam Rifle Act.
Now, is there any deeming provision for adopting the Army Act?
In that aspect of the
Yes, so we'll
matter,
we'll come back to you. What do you say on this aspect? Is it a fact that
The Assam Rifle was under the Assam Rifle
Army Act? Okay.
Yes. Then the Assam Rifle rules
1941
was published in the year 2009.
Okay.
So he was discharged in the year 2008 under the Army Act.
2008.
Yes, that was when the Army Act was.
Okay. Yes. What do you say?
No, my lord, it was 1941 Act. What he is speaking is about 2006 Act.
2009 Act, he said.
Yes.
But
October
you were
2009.
no, we are dismissed in the year 2008 before promulgation of the Assam Rifles
That
Act.
is 2000 Act,
Yes.
6 Act, what we are talking. I was under 1941 Act.
Okay.
So the question of applying the Navy Act or Assam Army or Air Force doesn't arise. To that effect, I've
1941 is what act? Which act is of
Assam
1941?
Rifle Act.
There was an act of 1941 itself.
Yes. It was replaced by 2006 Act, which was promulgated in 2009.
Oh, that is a different aspect, but
That is a different aspect.
your contention is that in 1941 itself, there was an Assam Rifles Act,
Malo,
and that was replaced or not, that's a different matter, but all along there has been an Assam Rifles Act.
malo.
Without applying that, they had applied the Army Act,
Yes.
which is not applicable.
No.
That is your case.
No. That is my para 10.
Let us have the Assam Rifles Act and the Army Act.
Nineteen 1950, my lord, yes. Only one copy.
This is the Army Act. Where is the Assam Rifles Act? You said 1950, 41 is an Assam Rifles Act. If you have this, please. F1 Rifles Act. It is there in the pleadings, don't worry. The annexure, there is an affidavit in opposition by 1, 2, and 3. And page 20, the Assam Rifles Act of 1941 is there.
My lord.
You are correct. So, so why did you apply for Army Act against him?
Lordship, because the Assam Rifle Act 2006
No, let's not
We'll
confuse
come back.
2006.
We'll-
was published in the Gazette.
Yes.
Yes.
Was published in the Gazette only on February 20, 2009.
No, that is okay, but
So this
Yes.
was not applicable. That time when he was discharged, in the.
no, this Act of 1941,
Yes.
was it applicable or not?
It was not applicable if they did under the Army Act. Some rifle personnels, they were under the Army Act. And as per the Army Act, he was discharged. And that was in the year 2000.
Now you come to your affidavit in opposition,
Yes, Lordship.
page 20,
Yes, Lordship.
annexure 1. Your affidavit in opposition by 1, 2, and 3.
Lordship, in my affidavit, it's only page
Page 20.
7 till 7 only.
Now you have,
I think it's the. This is
Yes.
Lordship, under the Assam Rifle Act 1941.
Yes.
That should be read with record office memorandum.
correct.
So the record office memorandum says that once a personnel get 5 red ink mark, they are liable to be discharged by the command.
No, his contention is that you had applied the Army Act. Is it a correct fact? If you had the powers under the Assam Rifles Act to dismiss him from service for many reasons, maybe red, 3, 5 red, or any other reasons for misconduct, then why did you take recourse to another act? There may be some reasons. Do you have any reasons, or have you assigned any reasons? It cannot be that one organization taking recourse of another organization's act, just like that. There may be some reasons. You can spell out the reasons. We can at least.
No, my first stance is that.
We'll come back to
Yes.
you. We'll come back to you. We'll hear you properly. We'll just trying to get some response from the council.
Yes, Lordship. Maybe there was some mistake conduct in
Comprehending. But that will be a ground for.
but in any way, whether it be under the Assam Rifle Act or whether it be the Army Act, Lordship, if the personnel they get 5 red entry in their dossier service record, they are immediately liable to be discharged. And the petitioner has already received 5 red entries in service process, be it in the Army Act or the Assam Rifle Act.
Let us see the impugned order.
First is warning, page 15.
No, where is the impugned order by which you have been discharged from service? Page
20.
20 of your writ petition.
Yes. The genesis starts from page 14. Warning. Page copy is page 15.
But at page 20, all the actions are taken by under the Assam Rifles Act.
My lord, that is what my contention is. That is my whole case.
No, under the Assam Rifles Act.
Yes.
You belong to the Assam Rifles.
I belong to the Assam Rifle.
So
I am subject to the Assam Rifle Act in rules.
No, the impugned order has been taken as per the Assam Rifles Act itself.
My lord, the genesis goes back to page 15. They didn't refer under what provision I was punished. They've taken it at
No, why do you go to 15? Come to page 20.
My lord,
Please.
I understand your lordship query.
Please read
But
this.
one thing is that the punishment which is reflected here is not in Assam Rifle. When Army Act is applied, why?
Let us see section 4 of the Assam Rifles Act. Section 4 of the Assam Rifles Act. No, 41. Section 4. This we have, don't worry. This is 19. In the trainings. Yes, we have. Section 4. What is section 4? Appointments and discharge. Before any person. Section 4 is section 4 of the 41 Act pertains to appointment and discharge. So, and section 4 has been referred in the impugned order. So where is the illegality?
My lord, what I'm saying is that when the punishment is under the Navy Act, see, can somebody be discharged on Army rules or Act?
No, where is the reference to the Army Act?
My lord, reference come, that is what I'm saying.
Yes, let us show us.
So let's go to the first one.
Page 15.
15.
Yes.
This is the type copy of page 2. Page 14. Warning is what for? You are enrolled in on such and such in Assam Rifles directly. During your service of 5 years such in such days, you have incurred 3 entries in your record of service. The details, what are the details given below? Army Act 39A, absenting himself without leave. 2 is Army Act Section 39A, absenting himself without leave. Second charge is Army Act Section 48, intoxication. Then Army Act Section 9B, without sufficient cause overstaying leave granted to him. This is the genesis, my lord. It is clear from the above that you, in spite of having advised many times, improve your such and such, you are hereby warned to be more careful in your conduct. If you incur fraudulent entry in your service document, then action will be taken to discharge you from service under Assam Rifle Act. So somebody is punishing Navy Act, and they are trying to say that you will be charged under Navy Act. Action will be taken under Assam Rifle Act. That is what you are saying. Then show cause notice also is the same. Army Act, B also Army Act, C also Army Act.
But what about, see, you have tried to develop a ground in these proceedings, but at page 19, your reply, what have you stated there? Page 19.
Page 19, my lord, what I'm trying to project to your lordship is that this is the petitioner do know how to write also, even in
No,
basic English.
we are not on the English. We are not on the use of expressions.
My lord.
We are on the intention. What intention did he wanted to express?
My lord,
He said, this is my humble request that I have been charged due to some mistake for which I am unable to continue my service, for which I do not have any objection. Sir, please, I am requesting you to kindly give me a chance to prove the related all kinds of civil service codes. There is no reference to any point regarding the
My lord,
jurisdiction.
I understand that. You will query. But what the petitioner was trying to see is that give me a chance to prove it is on. Maybe he was ignorant of the law. That is the record itself speak on its own.
And tell us one thing, when was this impugned order? Of which year? Which year?
16 January 2008.
When did you approach this court?
My lord, in 2018.
18.
Because of that, yes, earlier order, in 2018, the petitioner filed a writ petition.
Yes.
Yes. 1/88 of 2018.
Yes.
At that time only, he came up with this discharge order. Till that, the petitioner was not furnished with this order. It was only the affidavit in opposition.
What was the cause of action in 1/28 of 2018?
My lord, we challenged the discharge order certificate without this order.
Where is the discharge certificate? Which year? Where is the earlier of the order of this court?
Earlier order of this court is Annexure 1.
Of your writ petition?
Yes.
You had withdrawn.
Yes, with liberty, for the reason that without challenging the discharge order, this court cannot give an effective order.
What was the cause of action?
In the earlier proceeding,
Yes.
my lord, I challenge only the discharge certificate.
Dated? What was the date of the discharge certificate?
17/1/2008.
Seventeen one 2008 discharge certificate challenged after 10 years.
My lord,
What was the explanation?
my lord, there was a continuation application in the present proceeding, which was decided by this honorable court.
Where was the decision? You have withdrawn the writ petition.
My lord, in the present writ petition, that is in writ petition 72 of 2021.
Present one.
Yes,
Which order?
there was an IA order was none.
I.
Yes. My lord, my affidavit in reply, page 9 may be seen.
The section 5 is not maintainable. It was closed. No orders were passed.
My lord, the delay was considered. That is why in the
No,
main petition.
IA delay was not considered. There is, we are reading the order passed on 1/8/2023.
My lord,
You
in
will
view of the order passed today in IA, they said it was closed. Let this petition be proceeded.
proceeded, yes.
Yes.
But the delay factor has yet to be adjudicated. You have to explain the delay.
My lord,
Kindly have a look at the order dated 1/8/2023 passed in the IA.
my lord,
It appears IA has been filed for condemnation of delay of so and so. Learned counsel for the applicant as well as CGC submits that Section 5 Limitation Act applicable application is not maintainable. Considering the submission made so and so, the Section 5 is not maintainable in case of delay of filing of writ petition.
my lord.
But your latches you have to explain.
My lord, I have explained in the
Where?
application.
Where?
In
Not
the
in
IA.
the IA was closed. IA were not opening.
My lord, this was considered. And it was closed.
No, there was no positive order that we have condemned the delay. That delay hurdle is still there. You have to overcome that delay hurdle.
My lord, after overcoming the delay only, this order was passed by this court.
Sorry, that is not the correct
My lord.
interpretation.
Yes.
That is not the correct interpretation. No orders were passed on merits. The IA was simply closed. Section 5 is not applicable.
In the writ petition.
Writ petition.
That's what I.
Yes, that is the
Yes.
correct interpretation. But the question of your latches, we may not be effectively on the strict application of Limitation Act in the writ proceedings. Section 5 may not come, but the question of latches of 10 years in approaching the court, that you have to make some explanation.
It's 13 years.
13 years.
But one fact remains that this discharge, it was not furnished in the petition all along. For whatever reason.
No, you have said that the discharge certificate was dated 17/1/2018. It is not a case that the discharge, no, 2008 discharge certificate. When was the discharge certificate dated? What is the date of the discharge certificate? Which was challenged in the earlier writ petition?
Impugn discharge is 17/01/2008.
8. It is not a case that discharge was much later and the discharge order was of 2008. Same, almost same time. You did not have somehow the copy of the order. You had the certificate.
My lord, this honorable court has to take into consideration of the fact that a order which affects the person. This it should be furnished.
No, you are
It was
absolutely,
never furnished to him.
you are absolutely correct that the liberty was granted to you to challenge the actual order, which you have done. But the challenge which you have made have to be examined in accordance with law.
My lord,
First, you have to overcome the 10 years delay in approaching. Go to the date of 2021. Let us assume we had filed in 2018.
yes,
Then also there is 10 years delay.
yes.
How do you explain the 10 years?
My lord, when I challenged the discharge certificate, he came up with the impugn order,
No,
the present impugn order.
the challenge of the discharge certificate we are questioning, Mr. Counsel. We are not on the, even in the aspect of the discharge order, even the certificate. You took 10 years to challenge a certificate which has affected you.
My lord, the petitioner applied RTA after RTA.
Let us see. Let us see. Where are your RTA application? Where are the pleadings?
Page 38.
Of the writ petition.
Yes.
This was in 2017.
Yes.
RTA after 9 years.
My lord.
And see the application. This application was made by a lawyer, not even stating that he was the lawyer of the particular party.
My lord, I understand that. I understand.
Cannot be a fit case for interference.
My lord, in this one, order where it is clear stated that no army act is applicable to assembly. That's
We'll consider that.
42, my lord.
We'll consider that.
No,
Consider that. Okay.
much obliged.
Anything you'd like to say?
My worship, I come to my academic position, page 6. Explained why army act was applied.
Page 6.
Page 6, paragraph 5, remind 5.
Yes.
May I read, Worship? It is also submitted that the Assam Rifle Act 2006 has come into force on 2009 when it was published in the official gazette of India. The Assam Rifle Rules 2010 were framed under Worship. Before coming into force of the Assam Rifle Act 2006, the Assam Rifle Rules 2010, the Assam Rifle Act 2014 was applicable for Assam Rifle personnel operating under the operational control of the Army. The petitioner was also subject to Army Act 1950, as his unit was operating under the operational control of the Army. During the period, he was awarded for
Okay.
punishment.
Okay.
So when the punishment was about that he was under the governed by the Army Act. So the impunity order was passed under the Army Act.
But under the original Assam Rifles Act of 1941,
Yes.
there were no sections or provision under which this kind of misconduct offense could have been are listed as offense.
Lordship, as I said, the petitioner was also subject to the Army Act.
No,
It's
see,
clearly stated there.
he is substantially appointed with a particular organization called the Assam Rifles.
Yes, Lordship.
It had an act of 1941.
No,
No manner of doubt.
no.
It's an admitted position that when this proceeding was initiated, he was a personnel under the Assam Rifles,
No.
wherein you had a 1941 act. Okay,
Lordship, as per my information received just now, it says that the Assam Rifle Act 1941 was applicable only at Shillong. Only at Shillong. Or otherwise, those who were
you cannot make this submission. Let us see where you, from where you have made this
no,
submission.
Lordship, it's not in my, it's not in my affidavit.
You can make that submission, but it has to be backed by the act, something in the act. Let us see where it extends. It extends to whole of India, applies to members of, they may be serving to.
I'm sorry for the interruption. The Army Act was applicable to all the headquarters except in Shillong. That is the information that I have.
So that submission won't help you.
So let me find an additional affidavit, Lordship.
Not where we're disposing of. You're not being able to give proper explanation to that, but there are other points. Let's see. Oh, okay. Please wait.
And in any case, Lordship, there is a delay of 13 years. Even after they have
13 years, we may not say, we may say 10 years, because he had come to the court in 2018. It's a different matter that he had put to challenge the discharge certificate, not the discharge order. And so he was given liberty while withdrawing the earlier writ petition.
Yes,
So
yes, given the liberty.
but 10 years also is a long enough delay. We may on that aspect, let's see. Okay. An order of discharge from service dated 16/1/2008, by which with regard to the petitioner from the Assam Rifles is the subject matter of challenge in this writ petition. Full stop. The primary contention is that wrong provisions of an act which is inapplicable to the petitioner have been applied, which had culminated in the order of discharge. Full stop. Para. A brief narration of the facts would be necessary for adjudication of the issue raised. Para. The petitioner was serving with the 10th Assam Rifles in the rank of Rifleman GD when he was served with a show cause notice dated 14/12/2007, full stop. Prior to the same, the petitioner was served with warning letter dated 7/10/2006. Full stop. After consideration of the reply, comma, wide the impugned order dated 16/1/2008, comma, the petitioner was discharged from service with effect from 18/1/2008. Full stop. It was stated that the discharge was on incurring 4 red ink entries in the services. Full stop. The petitioner had earlier filed a writ petition WPC 128 of 2018 before this court, wherein he had put to challenge the discharge certificate. Full stop. However, from the affidavit in opposition, comma, the petitioner could come to learn about the order of 16/1/2008, and therefore the said writ petition was withdrawn on 1/4/2019. However, with liberty to file afresh. Full stop. Para. I have heard Sri so learned counsel for the petitioner, whereas the respondents are represented by Sri so learned CGC. Full stop. The materials placed before this court have been duly considered. Full stop. Para. The learned counsel for the petitioner has structured the challenge to the impugned order dated 16/1/2008, mainly on the ground that the same is based on certain allegations, not under the Assam Rifles Act, but under the Army Act. Full stop. By drawing the attention of this court to the show cause notice dated 19/12/2007, comma, the learned counsel has submitted that 4 numbers of offense were stated and all were under section under various provisions of the Army Act. Full stop. He has submitted that specific reference has been made to section 39 within bracket small a and 63 of the Army Act. Full stop. He submits that when the genesis of the impugned action can be related back to application of the Army Act, comma, the impugned order is wholly unsustainable in law and accordingly liable to be set aside and quashed. Full stop. As regards the as regards the reply by the petitioner to the show cause notice, comma, the learned counsel has clarified that this court may not go into the expressions used, as the petitioner was not aware of the intricacies involved in law. Full stop. However, the said reply would indicate that the petitioner was to be given a chance to prove, given another chance, full stop. Para. Sri so-and-so, Leonard CGC has at the outset raised the preliminary objection of delay and latches in approaching the court. Full stop. It is submitted that the discharge order is dated 16/1/2008, whereas the instant writ petition has been filed only on 12/4/2021. That is after a delay of almost 13 years. 13 years, full stop. With regard to the merits of the case, the learned counsel has submitted that the petitioner was found to be indulging in misconduct of various nature for which he was given warning from time to time, including red entries in the service book. Full stop. As regards the grounds projected for the present challenge, the learned counsel has drawn the attention of this court to the affidavit in opposition filed on 1/11/2023. More specifically, the averments made in paragraph small Roman 4, small Roman 5 of heading A, wherein a brief history of the case has been given. Full stop. He submits that though the Assam Rifles Act 1941 was applicable, the petitioner was subjected to the Army Act 1950 as his unit was operating under the operational control of the army when he was awarded the 4 punishments. Full stop. It is further submitted that the earlier punishments were never put to challenge by the petitioner in any proceedings. Full stop. This court has also been informed that subsequently the Assam Rifles Act 2006 and the Assam Rifle Rules of 2010 had come into operation. Full stop. Para. The learned counsel for the petitioner in his rejoinder has submitted that the aspect of delay was explained in this proceeding by filing IA 53 of 2021. Full stop. He, however, which was closed wide order dated 1/8/2023. Full stop. He has further submitted that in a writ proceeding, no, don't write this. He has further submitted that the subsequent Assam Rifles Act of 2000, Assam Rifles Act of 2006 and the rules of 2010 would not be relevant, as all along the Act of 1941 was in operation. Full stop. Para. The rival contentions have been duly considered. Full stop. Para. The writ petition has been structured, as indicated above, on the ground that the show cause notice, which is the basis, which is submitted to be the basis of the impugned order, mentions the Army Act and not the provisions of the Assam Rifles Act. Full stop. The aforesaid contention has been replied on behalf of the respondents by submitting that the earlier 4 punishments inflicted on the petitioner was at a time when he was under the operational control of the unit of army. Full stop. To examine the said issue, this court has had a careful examination, a careful perusal of the show cause notice. Full stop. Though it is true that the earlier punishments were inflicted in terms of certain provisions of the Army Act, the present show cause notice was issued on 19/12/2007 under Section 4A of the Assam Rifles Act 1941, read with ROI 4 of 2019 and paragraph 24 of chapter 8 of the Assam Rifles Manual. You will get this from page 16. Huh? The discharge order is mainly on the aspect of there being 4 red ink entries in the service of the petitioner. Full stop. The point which is required to be noted is that the action of putting 4 red entries in the service of the petitioner was never the subject matter of challenge in any proceedings. Full stop. The present impugned order is a culmination of the show cause notice, which was indeed issued under the provisions of the Assam Rifles Act 1941. Full stop. In the considered opinion of this court, the submissions made on behalf of the petitioner and the challenge projected do not appear to be in accordance, do not appear to be a sustainable and tenable proposition. Full stop. The reply to the show cause notice also indicates an admission. Full stop. Nonetheless, the discharge is on the ground of having 4 red ink entries in the service book and is not on any subjective satisfaction of the disciplinary authority, wherein there could be any element of bias or procedural impropriety. Full stop. The discharge is based on objective materials, namely the 4 red entries in the service book, which is admitted fact. Full stop. Para. With regard to the aspect of delay, comma, though it is submitted that the first writ petition, that this is the second writ petition which had to be filed on coming to know about the impugned discharge order dated 16/1/2008 in the earlier proceeding, namely WPC 128 of 2018, comma, this court is of the opinion that the conduct of a writ petitioner approaching a court is of paramount importance, as this court exercises equitable jurisdiction. Full stop. Though an explanation has been tried to be given that information was sought under the RTI Act, comma, such information, such application for RTI is also of the year 2017. Full stop. As regards the submission that orders were passed in IS Civil 53 of 2021, comma, a perusal of the order dated 1/8/2023 would, however, show that the application was closed as Section 5, as such an application under Section 5 of the Limitation Act 1963 is not maintainable in a writ proceedings. Full stop. Para. It is a subtle law that the Limitation Act per se would not have a strict application in filing of a writ petition. Full stop. However, it is equally important that the aspect of laches is a relevant aspect which is required to be considered. Full stop. Para. In the Honorable Supreme Court, a constitutional bench of the Honorable Supreme Court, in the case of State of Madhya Pradesh versus Bhai Lal Bhai, reported in AIR 1962 SC 1004, has laid down as follows. Paragraph 21. I'll give you the para. In the instant case, comma, even assuming that the period is to be construed not from filing of this case, but of the previous case, which was in the year 2018, comma, then also, comma, there is a delay of almost a decade, which is not adequately explained in the writ petition. Full stop. As observed above, comma, though there is no requirement under the law to file any application under Section 5 of the Limitation Act, comma, in the writ petition itself, comma, there should be sufficient pleadings in case there is any delay in filing, in approaching this court with any cause of action, which is not there. Full stop. Para. In view of the aforesaid discussion and the facts and circumstances, comma, this court is of the opinion that no relief can be granted to the petitioner in this case, and accordingly, The writ petition is dismissed. No order is to post.
Much.
Finished. I'll give you the suggestions. Okay?